So my name is Violette. I am a real estate attorney licensed in the state of Florida. Today, what we're talking about, and today is August 8th, okay, 2024. So if you are watching this video, I'm going to assume these forms are going to be modified multiple times in the next several months. So if you're watching this video and it's September, October, November, December, you need to verify that they haven't changed the forms. And the way you do that is you're going to look at the bottom left hand of every form. And like, for instance, we're going to start with this form, which is the ERS 20TN. They try to make them simple for you. So ERS is exclusive right of sale, ERS. 20 is going to be the version. TN kind of tells you you start as a single agent but can transition into a transactional broker. Now, what I have are the red line versions of the documents because you should already know everything that's in black. That has not changed based on these forms. So we don't necessarily need to go over that unless you have a question on it, then we can, but I'm going to skip only to the things that have changed. First thing you see is now they're using the term brokerage and or broker, which really in your world don't care. Where you see broker, that is not your name. Keller Williams Emerald Coast, right?
Keller Williams
Realty Emerald Coast. That's what should be in all brokerages, not you. Now, I have heard some people will do the brokerage / then your name just to help identify. I don't see anything wrong with that, but it can't just be, thank you. It just can't be your name. Make sense?
Yeah.
Because you are not the broker. You may be a broker associate, but you are not the broker.
Who is their broker?
A broker, y'all.
How about Keller Williams Realty Emerald Coast? There's your broker.
Yes.
All right. So we're skipping down. One thing you're going to also note is they are removing terms like commission. There's no more commission. It's either a concession or a compensation. So start learning the new lingo, because if you're still using the word commission, people who are up to date on this stuff are going to realize you may or may not know exactly what you're talking about. So all they're doing in line 37 essentially is changing the terminology from whatever to concessions. Broker's obligation, the addition here is this includes, except when not in seller's best interest, cooperating, communicating with other brokers, and making property available for showings. Because since you no longer are allowed to advertise or do anything in the MLS, you now have to, quote, cooperate and communicate with other brokers. At the very bottom, it doesn't really matter, but they got rid of the term sales associate and used the term authorized associate. Why? Nobody knows. Doesn't really matter. Nobody cares. But they crossed it out. All right. Still nothing exciting.
What's the green stuff?
The new word.
The language that they have to use. Says the parties acknowledge this form should not be used to share offers of compensation to buyer brokers or other buyer representatives via any field.
I don't know what the green means other than maybe it's been moved, because this is exactly the same language in Scrum.
Oh, you broke it.
You gotta touch the other screen.
Whoops.
The other screen.
All right, what just happened?
Go back.
Go back.
Use your finger to go back.
Forward.
Click the forward button.
The other, yeah.
All right. Woo! We almost had a CrowdStrike moment.
Do you have a remote electronic mouse?
Yeah, this thing is
Do you want me to bring my mouse? Would that be easier?
So the green thing means, is the green stuff always gonna be on there now? Or
So there should be a legend somewhere that tells you what those mean, but I just think, so if you notice, the same language at the bottom is there. So I think what they're just saying is they're relocating the same language. That would be my guess. But the green is not material for art purposes. So as far as indemnifying broker, they've removed the court arbitration because they effectively took a whole paragraph later in this that we'll talk about. If there's a dispute First it goes to mediation, and then if you initial, it goes to arbitration. And do you know what the brokerage's preference is? Do you guys initial, we want it to go to arbitration, or do you not initial and then it doesn't go to arbitration? Or do we not know?
I don't know.
I think one of them are not.
Okay, less initials is better.
Hey, go up 1 second. I have a question.
Uh-huh.
I'm agreeing. We'll be out of here tomorrow night. All right, this should not be shared among other people. Is that what it says?
Yeah.
Where are you reading this?
In the green.
The one where it says the parties acknowledge this form.
And it should not be used to.
Right, in other words, you're not supposed to upload this into
In the
MLS.
MLS.
So again, the whole thing of this is if you upload or you put anything in
This is
MLS,
for our class.
correct, it talks about anything having to do with compensation or commission sharing or anything like that. Keller Williams is in violation and all that things happen.
So this is for.
Right. So if you are faced with a question of, do I post this in the MLS or not? If you even think it has anything to do with commission or sharing of commission or anything to do with the commission, the answer is always going to be no. Now, even though this is not in red, we're still going to talk about compensation because when you're doing your listings, this is the section you're putting in as far as a listing agent. Okay. I hope that works. Yeah. Excellent. Yeah, so much better. Right. I don't have a laptop. So, yeah. All right. So this is where you as a listing agent is going to say how much you want to get paid your commission. There will be another section in here that will talk about, so if you put 6% here, there's another section that talks about if the seller selects it, how much they're going to pay out if a buyer shows up with an agent. So I'm going to assume most of the time that's going to be a 6% number. But this is where the change comes in because you tell the list or the seller, I'm going to put 6% in there, and they go, hold on a second, I've seen you do. And we're not doing 6 anymore. I know my rights or something like that. You're gonna have to have your scripts, and you have to be aware of how to handle a seller who says, timeout flag on the play. I don't agree. We're putting 6 there. So you're going to have to know how to explain to them why that needs to be a 6 or whatever you guys normally do. I used
So
to.
something has to be there.
Mhm. That's where you as the listing agent is agreeing with the seller how much the commission is going to be. Okay, that's the whole
The
tone.
total. The total.
The total amount. Yep.
It's always
Right.
been that way.
Yeah,
Right.
Right.
always been 6%.
Right, but there was a
It's
question,
always been-
there was a question of, well, if we're offering out 3% to the buyer's agent, does that mean seller's paying me 6 and now we're paying 3%?
But it's
So,
always been that wording.
That's correct.
That did not change.
no.
Yeah, but the number might change, right? It
Yeah.
could be a 3 if you're only paying me.
Right.
So that's where that's exactly the point
You
I'm
fill it
making, is a seller may say, let's start at 3, because as we get down here, he's gonna say, I'm not willing to pay anything to a buyer's agent. Now, remember, you can always,
You know, I'm not listening, no.
well, see, and those are gonna be preferences, but we don't know who's out there or what, so. All right.
Go back up
Yeah.
to,
Yeah.
a price plus dollar figure. What would most of us?
That's
put
the
in?
bonus.
Hold on a second. So there's transactions. Some agencies, not this one maybe, but some agencies say, hey, we charge a $375 transaction fee.
Transaction.
So I want my 6% plus you're gonna pay that transaction fee.
That's where it goes.
If you don't put that in there, you're not entitled to get it and you're gonna eat it. You're also going to see that on the buyer, and that's probably where it comes in more, the buyer's agreement. It'll have the same exact language, but that's gonna be, let's say you have a TC and you talk to your buyers and you say, I have somebody that helps me out and they do all this stuff. It doesn't come out of the commission, so you're gonna pay $350 for this. You understand that? If you don't put that in the buyer's agreement, you're gonna eat that.
So,
Right, we're in the listing right now. Correct. I doubt, has anybody ever even done this one may not be there yet. I was gonna say retained, but that's not there yet. Okay. So we have this section, which is going to be the notice to the seller regarding a buyer's broker. So this is kind of where things, well, actually right here, here's your standard. Now what's interesting is Florida Association of Realtors says it must be in conspicuous language. From a legal standpoint, that means bold and no less than 12 font. That's not bold and that's not. So, but I guess they're considering conspicuous language. So here's your language about brokers' commissions are not set by law and are fully negotiable. That's one of the two things that apparently is going to change the world. So now everybody's more aware, right? Right. But now they really know because it's in writing. All right, so this is where you're informing a seller that, hey, guess what? We have a relationship, but there may be a buyer's agent coming along and they're gonna ask for, or maybe ask for some sort of commission, or it could be me. I'm your listing agent currently, but I may bring you a buyer. So here is a revision to that says that the buyer's broker, even if compensated by the seller, so notice how it says compensated, will provide services for the buyer. We're not talking about the listing agent providing services for the seller, because that's covered in the other stuff. This is notifying the seller that, hey, there may be another agent coming that's going to provide services for the buyer that you may agree to pay. So apparently now it's an option for them. Seller is advised and aware that seller may, but is not required to compensate a buyer's broker upon closing. Again, how many sellers read this stuff? None. So you're going to have to, as a listing agent, make sure, however you want to cover this, whether you want to bring it up, not bring it up, discuss it with them, but you're supposed to inform them that they're not required anymore to pay a buyer's broker upon closing, depending on what contracts have been submitted and what's been signed. Seller may choose to enter into, and this is where, let's say the seller says, we're going to go 3% on the top paragraph 8, and I'm going to check nothing to the buyer's agent. That still doesn't mean the seller has to do that. If a contract is presented, there is going to be a separate written agreement to pay buyer's broker, or may approve broker to pay buyer's broker. So those are forms CASB and CABB. They're called compensation agreements. And one is called seller's broker to buyer's broker, and one is called where the seller is going to pay the buyer's broker. Yeah.
So if you're presenting it like that and the seller says, I'm not going to provide any compensation for the buyer's broker at this time.
Mhm.
Well, when someone contacts us and say 0%, very unlikely you're gonna get a contract. From
Yeah, well, I mean,
however,
right.
then I can't just say, you know what, send me an offer and put something in there, we'll see if it flies. I can't say that because it's not in here.
Well, you would start as a listing agent, hopefully explaining to a seller why originally that's a terrible idea and how you're eliminating a majority of the potential supply chain out there or demand out there. And if I say he, it doesn't matter. He, she, it, they, whatever they do in these cases. If that person still says, I hear what you're saying, no. Then when the buyer's agent calls up and says, what's going on with this? You can say, currently seller's position is they're not paying out, but feel free to submit offer with a compensation agreement and I will present it to the seller. That's all you can do. I know you don't like it, but those are the rules we've been handed and that's how it's gonna have to work. So there's
Actually gonna happen a lot.
Yeah.
right. So I think the odd thing is gonna be when a buyer's agent calls up and goes, I understand the seller's not, but do you think they would? I mean, that's probably what you're gonna get.
Yeah.
So, and that would lead us down a whole other thing that we're not going to talk about, which is, do you present those to the buyer or not present those to the buyer? And can you withhold those or not withhold them? And what if the buyer tells you specifically, I don't want to see any property bump? So that's for another day. I'm just telling you what this now says. So seller may choose to enter into a separate written agreement to pay buyer's broker. And like I said, that's going to be these forms right here. And that's
So you're
where,
saying these are in addition to the purchase sale agreement?
that's a modification. I don't want the
And
modification.
Mark, you would only
Question, you would only use those ones if, let's say, the seller didn't agree per his listing agreement, is that what you're saying? Like, if, let's say the seller agreed to pay a buyer, he did in this contract, right? Would you still need those or not?
The answer is yes.
Okay.
Because it used to be the MLS dictated commission
Oh,
split.
yeah.
Now, you have nothing in writing other than a listing agent saying, yeah, we agree to pay you until this gets signed.
Got it.
So
Right.
at the time
And
of the
he can
listing,
still not sign it though.
so at the time of the listing,
That is correct. You're gonna present an offer and you're gonna present
Those two
one
contracts,
of these.
one of those.
Right. Either the seller is going to agree to pay the broker or the seller has already authorized the listing broker to pay the buyer broker.
so at the time of our listing, we can have a buyer's or
You can
seller
have it
broker
signed.
to buyer's broker already signed, ready to just put in the buyer's name, buyer broker name. Correct? You know, sign
You
it.
just have it in your.
It's just, it
problem-
just says optional.
Yeah. I think the problem with that is as long as it's not in the MLS.
No, at the with the
You can have
listing
it
agreement.
pre-filled with
You
the
can have that
conception of the
pre-filled.
buyer.
You're talking about like in your forms, when somebody presents an offer, you're gonna have this.
I'm a listing agent. I can just have this pre-filled and when someone presents an offer, I just send it to them and say, fill it in.
Why wouldn't the buyer's agent fill this out and send it in?
Because here's the problem with that,
Uh-huh.
honestly, and I know we want to start brainstorming this.
Right.
We talked about it a lot. So the situation until this all unfolds and we all get used to it,
Mhm.
my concern as an agent, if I was on the buyer's side, is sending an offer with just that form and the seller signing off on the offer, but not signing off on the form, you're now in the contract with no compensation agreed on.
But now I think we can mention that in additional terms.
Right.
Right? Which we didn't mention that in additional terms in the past, but I think we can.
Not just, not.
So it would be like if you had to sell a property to buy a property, you're gonna have to know to start putting stuff in additional terms. It says the offer is contingent upon the seller executing the compensation agreement.
Yeah.
Oh, so it doesn't go through unless he does sign it.
Correct.
The offer is void. that you're
It's
signing.
contingent upon.
Correct.
Do you have to say buyer instructs on everything? I've been hearing that a lot. Say buyer instructs.
Right. So just to address that, you can watch as many videos as you want, and there's gonna be a lot of different interpretations. When it comes down to stuff like that, I would say go to the broker first, which is great for Andrew, because he's gonna have a million questions to answer. They either have a position or don't. If they don't have a position, then you can start determining on your own how to do it. And normally what I tell people is if it's more clear, do it that way, but a lot of times you think it's more clear and it's not. So my answer is, I don't know. I think do whatever makes it more clear. If that makes sense.
And we're playing attorney a little bit.
Well, again, nobody likes change, but
So, I know one person had brought up in one of the classes I took that and I thought, well, that makes a good point, especially if they have multiple listings, is if their seller is willing to offer, and again, it depends on how much is checked in the listing agreement. But if they are willing to say, pay X amount, and out of that X, you can pay the buyer's agent X amount, they're gonna use the buyer's broker, or seller's broker, buyer's broker, and but they go ahead and have that filled out when they're doing the listing agreement. And when I call up, say Sean Paul and said, hey, did your seller, offer compensation when they're about putting an offer in, they're gonna send me that form because it's already in their listing agreement. Now, mind you, as a buyer's agent, and let's say my form that I had my buyer sign is higher than what their form shows, I can always then still add to that and put that in the negotiations under the additional terms.
so we're basically trying to establish in the field which the best, better, greatest way to do it. Now, maybe Keller Williams comes up with, hey, all of our listing agents will have that, but maybe some other brokerages that are not as friendly are like, I'm not doing extra work, just send it to me. So it's gonna be all over the place. Yep, it'll be all over the place.
Like the condo docs and those too.
So- True story last week. We do settlement statements and, they, you know how special assessments on condos are very fact specific on effective date versus when the board approved versus when it's paid, right? So we get a phone call saying, hey, why am I paying the special assessment?
Thank you for handling that.
Okay, oh, shoot, I shouldn't say this then. That's right, it was on your So I called the other agent though, and I was like, You didn't even send us the condo, the, required condo, shoot, I hate that, you now know the person.
Right, yeah. But see, I wondered how.
Usually I try to leave the names out of it and nobody knows who I'm talking about.
All I did was forward it, and I was like, man, that was.
You know what, hey, you know what he said?
What?
That's none of your business. You don't need that rider.
Oh, wow, there's a lot of drama going on.
Yeah, I was like, you make it have fun. Here's why. So I had to call the buyer and go, listen, here is, I'm just a closing agent. I do what buyers and sellers tell me to. But here's what my logic was. And tell me if any of the dates are wrong. You know, here's the effective date of the contract. Here's when they approved it. Here's when it's paid. Anything wrong with that? No. Okay, now let's go to this line and you read it out loud and you tell me where that's not. He's like, oh, okay, got it. And then boom, it's done. So
So who did I say it?
on that specific thing, it was the buyer because the payment date wasn't until after closing.
After closing, yeah, buyer.
Okay, way off track. So compensation agreements. This one doesn't have, there are none that have the red line, but seller's broker to buy. I'm going to assume most of the time you're going to do a seller's broker to buyer, and just know that the seller paying buyer's broker, everything's exactly the same except for this little paragraph here that basically just says seller will pay the buyer's broker. But obviously you're going to put in brokers' names, not individual, not your name again. At this point, you're going under contract, so you should have an actual address. Whereas when we go over the exclusive buyer's agreements, currently my recommendation is in the buyer's agreement, you put counties. And since we're so close, if they go, I'm looking at Okaloosa, you may want to go one county left or one county right. I've heard people say, just do the whole state of Florida. However, you need to be aware that there is case law that says if it's too vague, it's unenforceable. Yeah, I don't know what they're going to consider. Yeah, well, who knows? The compensation agreement takes effect when a fully executed copy has been delivered to all parties. Well, this agreement will remain in effect for. So as far as I understand, you're submitting this with an offer. So at that moment in time, you don't have a fully executed document. So if left blank 30 days, so I guess you're guessing, like, how long do you think it's going to take the seller to either accept, reject it on this particular property? So that's kind of the time frame I believe they're looking for right there. In no event shall the term extend past the termination date of seller's broker's current listing. So if you submit an offer and it's never been accepted and all of a sudden the listing expires, then this expires, with the exception that if you're under contract, then it will extend all the way out till closing dates. Which means you're going to have to be careful because some agents, let's say you're doing offer, counter, and then the agent says, I got a great idea. Let's just clean all this up. Even though the last counter has been accepted, let's just clean up everything. Then you're risking possibly this being out of compliance because your termination may have ended if you put, I don't know, 2 days or something like that. Then you do a new contract with an effective date that's outside of this. See what I'm saying? So there's things that haven't been thought of. And again, if the seller wants to sell and the buyer wants to buy, usually you're not going to have a problem, even if it legally may have expired or something like that. Let's see what else we got.
So Mark, on that term date, what you were saying, we should almost put it for like the offer of acceptance or when the property would be like, let's say estimated closing.
No, this would just be for acceptance of the contract.
Okay.
Yeah. Because this language will automatically extend it through closing.
Mm-hmm.
Yeah. Seller, so again, this is the seller's broker, will compensate buyer's broker as stated below. So here's where you're putting your 3% or any bonuses. So from the buyer's side, this is what you're looking for.
So this form is only used if it's modified from the last form that we're just looking at?
No. This would, yeah, so I would think the better course is to submit this no matter what, because as a buyer's agent, you don't have the MLS anymore. So you're going to have to submit something to get it signed either by the seller or the listing broker agreeing to pay you something. Because if you don't have this, and we get a settlement statement and the listing agent says, yeah, don't worry about that agent. And you go, wait a second, I was the procuring cause of this, and like, okay, where's the signed document where the listing agent or seller agreed to pay commission to some buyer now? You know what I'm saying?
This is reflecting our listing agreement. The seller agreed to
That's
pay
not
the
an apple.
compensation, so this is our broker promising the buyer's broker to pay that. So why not send it?
Well, so like a closing, we don't get a copy of your listing agreement, I don't know.
No, I'm just saying that this is not a big deal because it's just the seller's broker to the buyer's broker. This isn't anything for the seller to even sign.
How many times have, so I know a bunch of times, we've had a closing, we sent out settlement statement, buyer's agent comes up and goes, they promised me we could go 50-50 even though. And then who are we supposed to believe at that point?
So that's why in your listing package, this should just be in there because the sellers agreed to pay and.
I was gonna say, what does Doug say about compliance? Is he saying this is required after
I
August 12th?
sent it to him on my listings, but he isn't requiring it yet.
Well, you're on the listing side. What about the buying side? I mean, what?
So I don't have a contract on something, but
Yeah.
I filled this out, Doug signed it as the broker.
Mhm.
And now, when someone asks me and they want to do a contract, I said, here.
So in the past, when it was on the MLS and a buyer's agent had to prove what their commission is, what was the document of evidence that? Right, that doesn't exist anymore. If you don't have this, then what document do you have to prove what your commission is?
Exactly.
So I think the answer is yes, this is gonna be in every transaction now. So you have the listing agreement that says as a listing agent, how much the seller's agreeing to pay you and maybe pay out to a buyer's agent. Buyer's agent doesn't have access to that. They can call you whatever, that's not binding. They submit something, they're gonna have to get one of these two signed, I would imagine, in everything as proof that that's what they're entitled to. Otherwise, you have nothing in writing saying what your payment is. Yeah,
I've been to a lot of these classes, beat my head up against the wall many times.
right.
But I did come across some great verbiage and I'll just put out, so I told him I was gonna do things there. But in your contracts, because again, when you have a compensation agreement, it's not part of the contract between buyer and the seller. So they had a good idea, and they put it out there. So under the other and additional terms of an offer, you actually attach this as part of the contract. It says compensation agreement. It can be seller buyer broker or seller broker buyer broker. And then it just says basically that the seller will pay, that's concessions. The seller will compensate the buyer's broker the amount stated on the compensation agreement. Seller to buyer's broker form that is included as an addendum to this contract. So it creates an inclusiveness to the contract.
Mhm.
That way also the lender has that information because again, when you're working with buyers and they're cash poor, they will, and they're not going to be cash poor, but they're going to validate the funds. They're going to verify those funds for closing. And if they've got 15,000 closing costs, they're going to verify that, but if they don't know anything about a 2%, 3%, whatever that commission is, that they're going to have to pay as well, or that's going to be paid, they have to verify those as well. But this at least it connects it to the contract. So unlike you send one and they sign the contract, but not the compensation agreement.
Yeah. So it's, in essence, what you're saying is the contract itself must reference this agreement. The language.
Without a check box.
Right.
Yeah,
we do it again.
Well, that's okay, but every form has a
Well,
different person sign it.
not that yet, yeah.
It's like others, and you check it and.
Right.
Yeah.
I think it's good.
Right. So people come up with their own magical language on how they want to bind the two. But I think the bottom line is, if you're not, so they'll always say, you're not a part of the contract. The contract is between buyer and seller. Well, they're making you a part of the contract, for better or worse. You're now married to it and you're part of the negotiations. So it's going to have language in the original contract that is contingent or part of, or however you want to phrase it. But yeah, you've got to reference this. Otherwise, you could be left out. And what I don't like, again, which we can all, I'm sure we all hate stuff about this, is they're now pitting buyers agents against buyers. Because there's only enough money, and then the buyer's mentality is going to be, but for you, I should be able to get this thing cheaper and whatever. But you're going to have to deal with that.
Mark, if the listing agreement says 6% and this thing says 2%, is that an 8% listing?
No, that just means the listing is 6 and the seller is, or the listing agent's going to pay 2. So you will get 4 and 2.
Just like like it's always been.
Right.
If there's a closing at the end of this month and it's been a rocky ride already. And I have to now present this to.
No, when did it go under contract? Before August 12th, which hasn't occurred,
Yes,
then you don't have to worry about
so
it.
I do not have to bring this whole
Yeah.
drama up.
Anything that's under contract before August 12th, you're okay, you're grandfathered in, which I'm sure we'll change that
Unless your
language at some
broker
point.
wants you to sign something else.
Right, so the only thing they're saying on that is you're supposed to send a disclosure to the seller that, commissions are not set by state law, but I'm just, whatever, I'm curious about that. But the bottom line is, if you're under contract before, August 12th, in theory, you're okay with the MLS side of the world and the commission side of the
On
world.
the buyer's side,
Mhm,
I'm
correct.
representing the buyer on this one.
That is correct. Now, I don't know what to tell you if it cancels and they re-sign it, then you have to follow all the disclosures. If they just merely do a continuation of closing date, then you're still covered. Yeah.
What about listings that were signed before the August 12th?
Mhm.
I saw Shayna sent something out yesterday, a template that said how to get those into compliance, but it was just like a.
There's a modification of listing
Is there a thing
agreements.
about it?
There is one, yeah. August 6th, 2 days ago, they came out with some new forms.
I thought we don't have to do a modification, we just have to notice.
Into disclosure.
We have.
It depends on, so, all right, we're getting off track.
Understanding what she wanted.
All right, hold on a second, hold on. The listing agreements, the old one's not going to say, where's that? It's not gonna say brokerage commissions are not set by law and fully negotiable. That's the disclosure. After August 12th, you have to send the seller, okay? However, you're gonna have to look at all of your listing agreements. If it said, as the listing broker, you are required to put the commission in the MLS, now you have to do a modification to the listing that they've created, because it's gonna remove that and do the new disclosures. If it doesn't say you're required to post the compensation in the MLS, then the only thing you have to do is send that disclosure about the commission stuff.
Are they out there yet? Because I didn't get a notification.
It came out, August 6th. According to Joanna.
No. All right.
Look in form simplicity, you'll see the disclosure. If you see that. Okay, so not really important because you can't change it. This is where if there's a dispute, if you're initialing, it goes to arbitration. If you don't initial, then you basically sue them. And it's up to your broker whether you guys want to do arbitration or not, and we won't get into that. But again, be aware, there's two forms, seller broker and then seller to buyer's broker. So I think when you're doing buyer side, those have to be filled out and sent in, otherwise you're not protected. Questions on any of that?
You're an attorney, so which one would you recommend we use? Because there's a couple companies that are not doing broker to broker.
Then you have to use the other one. It's gonna have to be seller broker.
So the seller broker is
No.
better? you
No,
think?
it depends on what the
Legally?
seller has agreed to. If the seller says up in paragraph 8, and let me see.
No, I understand that, but there's a couple companies that are not doing broker to broker. There's a reason for that, right? As an
That means-
attorney,
They're not
right?
getting compensation for the selling side, they're not.
They came publicly and said, we're
Right.
not gonna do broker to broker.
That means when you
That's
submit
over.
an offer on behalf of the buyer, you're gonna have to use the seller
seller one.
to buyer's broker, correct?
So why is that covering them more than broker to broker? There's a reason they're doing it. That's what I'm trying to figure
Well,
out.
it may not work out for them long term.
Okay.
Well, first of all, wouldn't that be clear? I mean, at the end of the day, they're making a decision for a seller. They're making that decision point blank across the board, and
No.
that's the whole thing that Sky says.
It may appear that way. What they're doing is they're taking somebody who may not be aware of how it all works, listening to that person and going, hey, you're my agent, I'm gonna trust whatever you're saying is best for me. You may disagree with that, but the seller is voluntarily signing off on a contract and they're over the age of 18 and hopefully educated. And that's what they decided. Now, what'll happen is, after 60 days, when nobody's seen their property, but all the other properties around them are selling, they're probably gonna call up that agent and go, I don't understand what's going on here. That would be a fun little phone call to be on and see how they massage that in there, but I think that's what's
Do you have
gonna,
to show properties you're not getting paid for?
no. We'll leave it at that. Unless you're doing it, in a discriminatory manner.
There is,
Okay.
John, there is some good, I watched the Florida Realtors, Patty Ketchum was doing it a couple days ago. She had, I recorded it, because she had great verbiage that you could put actually in the listing agreement in additional terms, specifically spelling out that basically they don't want to look at anything that is not offering compensation to their agent. I'll be glad to.
It's on the e-card
Listing
website.
agreement.
No, the e-card, yeah.
But it's a buyer agreement.
No, this is on the, or I'm sorry, yeah, buyer broker. On the buyer broker agreement to where they do not have to show property to anyone not offering a compensation. But if you, Florida Realtors should have it. It was Patty Ketchum's, class like 2 days ago.
But there's a fine line. You don't have to show that property, but you do have to, if your buyer said, I want to see all 4 threes, and you know that one's not paying commission, you have to tell them about it. But you don't have to show it to them. The better way of doing it is you call the listing agent and say, a potential buyer, will you pay me a referral fee if I send them to you and let them deal with it? Well, you're on the listing side, so you may get that. And then at least you get something. But no, you don't have to work for free. Right.
But, I'm sorry, this is another pet peeve of mine, because I've seen a lot of the Facebook chatter, and which is crazy, some of it. But, like you mentioned that about sending a referral fee. Well, and we were in another course, with another attorney, and that question was asked about, does a buyer, they're gonna think that they can skirt around everything, not have to sign anything by going to the listing agent. And somebody put on there, oh, well, they can just tell you what to fill in, and you just fill in the form or whatever for the contract. At the end of the day, if you show the property because a buyer approached you to look at that listing, you're technically working for that buyer, even though you do represent the seller, that in their terms on all the Florida Realtors things, also with the other attorney, they do have to sign some type of showing agreement with that buyer to show compensation if they want to, but they have to sign something with the buyer. It's not like an open house where they just don't have to sign anything.
Okay, so this is what we talked about last week, which was if you're a listing agent and you're merely providing access to the property and you're not working for, and then they're starting to create, what does that mean? And there's some keywords for that, then you don't need anything signed by the buyer. If you have crossed the line, which we're not gonna sit here and talk about where that line is, then the answer is yes, you're supposed to get something signed by the buyer.
But would you say that you need to go get a pre-approval, and if they want to write an offer and you go to write that offer, aren't you technically working for the buyer at that point?
I don't know the answer yet. I mean, the question is, are you representing the seller's best interest? If the seller says, I want all pre-approvals, then I don't think the listing agent telling the buyer, we need a pre-approval before you do anything. And if the buyer says, here's my terms, and you say, on behalf of the seller, I will write up those terms, then I still think that's the best you have in this world where we don't necessarily know for certain. So the question is going to be, am I doing this because I represent the seller and I want the property to close? Or am I giving some sort of value or advice to a buyer other than what I'm doing representing the seller? If you cross that line, wherever that magical line is, then the answer is yes, you're supposed to get something signed by the buyer.
But in doing the buyer's offer, you still gotta do the copies of the agreement, right? The attachment, the commission.
If you've crossed the line, then you have to present something to the buyer and get it signed. Otherwise, what happens is the brokerage gets in trouble because now you're not complying with NAR's rules. And if the brokerage is not complying with NAR's rules, you can get sued outside the settlement agreement. Or the brokerage can.
Who's gonna sue us? The other agents?
The attorneys who find out that Keller Williams is constantly not following the new rules, and then boom, they'll sue Keller Williams.
Well, everybody in this room is single agent.
But you agreed to follow the terms of NAR when you settled. So now if the agents are not following the settlement terms, you're in breach of settlement terms, they can sue them.
Mark.
Yes.
I think Gary made a single. Single agent, the buyer's gonna have to sign for the company. Because, the other day, Andrew sent something out about getting the EPBA signed, because it does talk about that single agent.
Right.
Okay, but if in this situation, you have somebody approach you on a listing, and you're not really working with them, you could use the showing agreement or the pre-tour property agreement.
From the listing agent side?
Right, because we're gonna have to have them sign single agency anyways. to show them our listing,
No,
right?
no, no.
If it's your
So-
listing and they call you.
So, hold on.
You wanna be a non-rep to that buyer, because if you're not working for the buyer, you better have a non-rep,
Yeah.
because technically you're a transaction broker, therefore you are.
So how many people have watched the hour and 20 minute by Joanna, who is the attorney for Florida Association? Okay. I would follow her direction, not, I watched the video from somebody else, because she made it clear that if you're a listing agent and you're merely providing access for a potential purchaser who's not represented, they don't have to sign anything. There's going to be a working for definition that once you cross that line, then the answer is yes.
What about if somebody calls us about just general information and you set them up on a subscription in the MLS?
If you're soliciting them, I don't know, but for purposes of today, that was all asking stuff. And those questions will go on forever until we all figure out where the line is.
Clear as mud.
Right, correct. Well, I mean, with all change comes clear as mud stuff. Back to this, notice to seller regarding buyer's broker. So again, you're just notifying, this is notification to the seller. They're not signing or agreeing to anything. You're just kind of disclaiming to them that there could be another buyer's agent, or I, as a listing agent, may convert into be a buyer's agent. And if this occurs during the duration of listing, broker will be entitled to compensation in paragraph 8. So this is John. I'm a listing guy. I get my compensation per paragraph 8, as well as a buyer's broker compensation in paragraph 10 for services performed for the buyer. Now, hold on. I know what everybody's thinking. Let's go to 10. 10 is what the seller is willing to pay a buyer's broker. This is where it's going to say, if you do both sides, whatever you're getting from the buyer side comes out of that 6%. Got it? So the seller is not paying 6 plus 2 or 6 plus 3. Seller has 3 options when you meet with him at the listing appointment.
So the seller's max will be 6.
If you put 6 in paragraph 8.
Yeah.
Or you modify. Now, I will tell you, again, back to these videos, because I've seen them all. There can't be a video out there that I have not seen. There is a broker out of Tampa who said, when you enter an agreement, I think they did theirs early. That's why I put the date on there, because things will change. Unequivocally said, if you cannot sign an amendment to the buyer's agreement if the seller is willing to pay more. Cannot do it. Absolutely not. We all know now you can. So just be aware when you're watching this stuff. You try to look at the date it was recorded, but most of the time it doesn't say that. So just be careful. Seller authorizes broker to offer compensation to buyer's broker in the amount of. So this is kind of what you're used to in the MLS. You're just going to put whatever. Hey, I'm the seller. You're my listing agent. I'm going to pay out 6, and I want you to pay out 3 to a buyer's agent. This amount will be paid. So you're using a listing or a buyer's agent calls you and says, we want to go see this property, and is hinting about what's the situation, willing to pay out 3 from the broker. Now you know we use the broker to broker form. This compensation will be set forth in a separate written agreement. Whenever you see that, they're talking about those 2. Seller authorizes broker to offer compensation to buyer's broker from seller in the amount of that it does. Compensation will be set forth in a separate written agreement. So this is from the seller. I guess you would use this one if the seller says we're doing 3% in paragraph 8, and let them submit an offer to me about how much I'm willing to pay them. I'm not exactly sure in the fields like why sellers would choose one over another. I guess if people are running, say sellers running tight on the numbers and they don't want to guarantee paying out a certain amount. I don't know. You guys would know better when to use these, but this is what it says. So the top one's broker to broker. This one is seller to broker. So that's the other form. Or at this point, no compensation will be offered to the buyer's broker. And again, even if a seller checks that, they have the right to change their mind. If a buyer submits an offer and includes a seller to buyer's broker form and signs both of them, then that's what they agreed to.
Mark, quick
Yep.
question on B when we were just talking about that, because basically you said you could either do A or B, right? But with B, with you saying that the seller can change their mind, or with that, wouldn't they need to enter something on that? Like, let's say they still said, okay, I'll do 3%, but then they can still change it down the road and only do less because it's with the buyer. Cause you said on the second, like, section B, you said that's from seller to buyer. Or
No, the-
seller to buyer, yeah.
Yeah, so,
So like, let's say they said, okay, I'll do 3%, but they wanna do option B, right? If we
Right.
put 3% on this listing agreement, get it signed, and yet they'll still do a separate form with the buyer, then what if you said they could still negotiate that again and less or whatever, or no?
well, I mean, hadn't thought about that angle, because that's true, the seller hasn't accepted anything yet. I mean, this is between listing agent and seller.
Yeah.
I mean, ultimately what happened is, in the legal world, if the seller signed B and said 3%, and offer came in what they're asking for and 3%, and the seller said no, then your commission now has, in theory, vested, you get to go sue the seller. How many people do that? Yeah, right, no, none. So what I'm talking about is the no compensation will be offered to the buyer's broker. The seller can then change their mind and offer.
Oh, I got it.
If an offer comes in, they're like, yeah, I can do that.
Cause I was, in my mind, I was just thinking the difference between A and B. You know what I mean? Like, you know, like why would,
Right.
oh, you almost just do A, right? You know, how we normally would do it, but I guess.
Well, that's what I'm saying. I don't know at this moment in time, like in the field,
For sure.
when these things come up.
Agreed, yeah.
And- yeah.
No worries.
So I was thinking a good scenario, finding out about the A to B, cause it took me a minute, I missed it, cause I just scanned over it real quick, and I'm like, oh, that's seller, that's buyer, didn't even read the fine print. Which is that fine, but,
It's
so
conspicuous. What are you talking about?
A is a total commission, like old school, right? It's like the way we've always done business,
Correct.
8A. If you do 8A and the seller wants to pay a portion of that, they're gonna have to bill it, 10A. But if you wanna go into a listing appointment and you say, hey, Mr. Seller, here's my fee. Okay, you figure that out, awesome, oh, good, now we go down to 10. Now what do you wanna pay the buyer's agent? You can separate those, because then you're like, I'm gonna focus on my fee, now you can figure out what you wanna pay the buyer's agent kind of thing. You know, you can kind of have a separated conversation about that, and then talk about what the pros and cons, et cetera. That's kind of what I take away from it. You tell me if I'm wrong on that, I just.
No, A is total. This is what you're paying out to a buyer's agent.
And to see if somebody said, well, it's negotiable, that's because they've marked C on the listing agreement. If the agent says, well, it's negotiable,
Well,
they would.
That says no compensation.
no, the
Well, they say
listing,
it's not, because they don't have a flat, they don't have a
The-
number in mind.
the listing agent would have to say currently, the seller is saying none.
Exactly.
However, feel free to submit whatever you want to, and we'll see what they say.
Yeah.
That's what you'd have to say.
It's
But again, this is the script world. This is where you say to a seller, I highly recommend against doing this, and here's why. And it's your job to convince a seller never to check line 160, but I'll let you guys figure that part out. That's, and then again, since we're doing the TN, which is transaction, you start with single with the consent to go to transaction. And then all this other stuff is still the same.
Oh. And I'm just getting into two different worlds, I'm sorry.
That's okay.
Jody, but
Sorry.
Jody Wagner.
So, so I was in, like I said, another attorney's class a couple days earlier, I don't even know when it was, but anyway. So he brought up a good point, I just wanna see, because I thought, oh, interesting, so if you go back up to the paragraph above where the arbitration. Did that, cause he was saying, I just wanted. to
Conditional
make sure
termination? Yeah.
We're on the same page, because they were saying, if you initial, then you agree to arbitration. But now they actually have in here that you can do litigation versus just arbitration or mediation. But if you initial, then you have to go through arbitration mediation first, but if you don't initial, then you do have the choice to go straight to litigation if you wanted to. I was just curious.
Okay. So what this says is all controversies will first be done by mediation. Okay. Now, again, we have the legal side and we have this. What happens when seller goes, that's great, I'm not going to mediation or anything like that. That means the next step is if they refuse the mediation, you're allowed to file a lawsuit against them. And then everything goes in front of a judge. If they've initialed arbitration, you've got to try mediation first. If that fails, there is no lawsuit. You go to binding arbitration, which from an attorney standpoint is terrible because you go to somebody who is not a judge, who thinks they're a judge, They're gonna listen to facts that may or may not be admissible in a real court, and they're gonna make a ruling that's binding, and there's no appeal process to that. Whereas most of the time, we all know the buyer and or seller are probably wrong and are just refusing to pay you. So you would likely rather go through a litigation where you have a court of law and a judge. And if the judge is terrible, you have an appellate process to get reviewed and stuff like that. That comes from an attorney standpoint, but that's what this says. I don't know how that's different from whatever they say.
Well, no, so it's best not to initial, because if you initial, you're
Correct.
saying, I'm gonna go to arbitration
Correct.
first, you have no choice.
Correct.
But if you do not initial.
Well, mediation first, failing
Right.
goes to arbitration. So really, this is how it goes. Mediation no matter what, mediation no matter what.
If you initial that.
Yeah, then you either go litigation or you go arbitration because it's initial. If you do arbitration, I'll take it one step further. If you do if you initial arbitration and somebody files a lawsuit and their attorney files an answer, you've now waived arbitration.
Don't do it.
But
I've always said initials are already on there.
Initial
I'm just saying,
and
they
then-
should delete them.
And then you get another-
automatically there for what?
It automatically.
However, you can also act out.
It just, in the old listings, it always just had arbitration mediation. And then if you wanted a lawyer, you pay for that lawyer.
Right, so hold on a second. Who creates the form that automatic, like I create my own forms in Adobe?
They're just fillable initial spots.
Right.
So we just have to physically go in and delete them, but I've always just left them and they've been initial, but they pointed out that there was that change that now it actually has litigation in here, which means that if you win, then the other person is now liable for your attorney fee,
Even if you win an arbitration.
versus the other way around, but I just didn't know about the initial.
It's in there that says, each party to arbitration, pays their own,
Attorney's fee and.
yeah. So all I would say is then you need to remove it or get different, I don't know, because I don't see that side of the world. I can just tell you what it says.
Recommendation is to not initial them.
Correct.
The seller or the investor.
Correct.
Whatever you call
Correct.
it. Right. You pull the initial out. Total bill, total bill, so you just have to. Let it go.
All right. So any questions on the TN form? Yeah.
Going back to that 10B,
Uh-huh.
that seller buyer's broker.
Oh,
You,
10B.
yeah, so up top
Right.
in 8A,
Uh-huh.
let's say they decide 2.5%. That, okay. and-
Total in 10?
No, just to the listing agent, because they're gonna check this B, right? And then you have to put a percent in there, then they're gonna pay to the buying side, right? If you do A, that's where the split, that's where the split gets put in.
This amount will be paid from the broker to buyer's broker from the compensation amount agreed to in
Right,
paragraph A. So,
but if you
Don't go
decide
lower
to check B, let's say they check B,
uh-huh.
and let's say they decide, I'm gonna pay the, 2% to the buying side.
Mhm.
And then let's say you're in negotiations and it just comes out that they decide somehow, well, they're gonna pay 3% now. And then in the compensation agreement, seller to buyer's broker, it's signed for 3%. Does that trump this, or do we need to do a
Well, this one-
modification to this?
Yeah, if you'll notice, this one does not
You see what I'm
say
saying?
this amount comes out of paragraph 8.
No, right, leave paragraph 8, I'm just saying if they decide to do this B.
So, but a buyer's agreement that we already put 3 here.
Okay, well, yeah, let's say they
Or 2,
agree,
and this is a 3.
right, and then you're in negotiations and they decide
The seller,
to
so,
up it.
so
to
with
the
this-
buying
yeah.
agent.
so look at it this way.
So,
Here's
and
a,
then you
here's a
get
good way. Here's a good way to look at it. The seller in theory must agree to this at a minimum.
Mhm.
They can always agree more.
Right, and you get the compensation agreement, and that's gonna state, let's say it states more, let's say seller to buyers, to the buying agent,
Mhm.
let's say they upped it from this says 2, and let's say they sign for 3 on a compensation agreement.
Right.
Does that compensation agreement then trump what you put for this?
If the
We need-
seller signs
We
it.
need to modify this.
No, if the seller signs agreeing to pay 3% from the
Okay.
other agreements,
Okay, then we don't need to come back and modify this,
well, that'll probably be a
Because they
broker compliance question.
because then they can say, well, we agreed to 2, then now we sign, I mean, I don't.
Use a modification.
Well, you'll have this, and it's gonna be signed by the seller. So you'll notice the broker is signed by brokers, but this one's actually signed by the seller. So I don't know
I
why,
just don't know if we need to come back and modify it.
I mean, this would supersede, that'd be an internal question. I don't think you need to from a legal standpoint, because the seller has signed this.
And there'll be an updated, date.
Yeah, well, the date will be after the listing.
Yeah. I'm just trying, there's so many different like goals that can go on with this, so I'm just trying to like.
I think the main thing though is that, like in 8, you don't put 2,
You put 6.
thinking that it's 2 plus whatever you put here.
Right, no, I.
Those
get
are the
that.
major things that
Right.
you need to avoid. The rest of the
Right.
stuff is like, who cares kind of stuff, but you still need to know it.
I did care, because like her, there's so many damn loopholes on this one alone.
Well, plus you're gonna watch videos that are gonna say different stuff, and you're gonna have agents that don't know anything that's going on, even after the 12. Right. So that was, listen. And the good news is, all of the other, whether you do the 20 TB, the 20 SA, or the EBLA 12, it's all the same modifications. They're just making them conform. What's that?
I mean, I'm not.
We're like a nine.
I don't give a shit about any of this anyway.
When you go into,
Be careful.
let's see.
Read them all.
Oh, I have a question for you while you're looking at it.
So hold on, when you go into this and you go like, oh my God, look at all these listing agreements that have changed. All they did was basically made all the same changes to the different documents. So it looks terrible in the red line. But the changes we just went over are all the ones they incorporated into the other one. The only difference is the duty, whether you're a single agent, you have the right to convert to transactional, whether you're, whatever, exclusive. That's what the little initials are for. All right, any questions on listing?
I can ask something.
Yeah.
So on 8A or whatever,
Uh-huh.
if we're used to putting 6, we should continue to put 6 or 5. or
I would agree.
Right, yeah, continue to do that.
Everything.
Then when we get down to 10A, B, C, we can decide what's happening with the buyer side.
That's right.
And that'll come out of the 6, 5, 4, 3, 2, 1, whatever.
That's right. That's all right.
You can change it, it's not set in stone, that could be changed, right?
That's just a minimum. If they
It's
want to
stellar,
pay
yeah.
50,
If you put 6 right off the bat, they're gonna think, wow, you're charging a lot, you know what I mean, leave it out. And if they don't agree, then they automatically think you get that 6. Then you're gonna have to modify it.
you can always modify it.
Well, modify the language.
All right,
Go for 6.
one of the buyers.
Yeah.
Buyer, broker. We're on to the buyers. Buyer. I'm sorry, we're on to the consumers.
Yes. Yeah, it should be an exclusive brokerage agreement.
Correct. So I think what they're trying to do, from a legal standpoint, a consumer with a capital C has more protections under federal law than a buyer. And I think they're sneaking that in there to say now they're a consumer protected under federal laws. So when you violate it, the penalties are 10 times worse than if they were just a buyer under state law. That's my guess. I don't know, because why do they move it from buyer to consumer? So,
Lawyers is why.
yeah, those damn lawyers.
They still have that, have that, buyer beware. Consumer beware.
It'll always be buyer beware. Your broker, again, is gonna be Keller Williams Realty Emerald Coast. That doesn't change. In this one, for some reason, they added possessory, but in the other ones, they don't. Like, so this is the TN version. You're gonna have the SA version, you're gonna have the NR version, but they didn't include possessory in the other ones. I don't know why. I don't have an answer for you on that one.
I think there was discretion for it.
Yeah, it's a nice thing.
And who can sign these documents at the bottom, they're all different.
Oh, yeah,
If you look at actually the signature, they used to say sales associate
right.
and broker.
That was
and now
authorized,
they
yeah.
have authorized agent, one is just broker. It's like, okay, so we have to send all of these, we have to send the document to the broker directly.
Poor Andrew.
Well, eventually he'll have to DocuSign. Somebody will have to DocuSign, yeah.
And it's a compliance.
And again, the term, I mean, you guys are probably used to the term language. They're just changing consumer. And on type of property and location. So this is gonna depend, I think, if you have a buyer who says, I'm looking at one specific one, or if you have one that says, hey, I'm looking in this area, what do you got? We already talked about this. You could put single family, you could put condo, you could put vacant land, location, you can put Okaloosa County, Walton County, Bay County, whatever you want. I would leave it. Broader is better than narrow, but if you go too broad, like we talked about, maybe it's
Can
unenforceable.
you just say type of property residential? And that covers.
I would think so.
Townhouse, or the condo apartment.
Yep.
What?
I think you can.
Yeah,
Um,
say residential.
and let's see. So for this one, there's gonna be, some other ones that actually will have a property it'll say property, not type of property. So when they start saying type of, that's when you know get generic. And if it says property address or something like that, then get specific. Your obligations, some still the same, but, they've removed buyer assist in determining buyer's financial capability. So because I think you're now submitting your worth along with the contracts, I think what they're saying is you really shouldn't get with the buyer on their financial situation. You can still say, go get pre-approved and give me the letter because we need to submit that. But they don't want you assisting the buyer. Except for, we'll get there, which will be fun.
Credit report.
Right, except for that, but we'll get there. So you're not gonna determine their capability, but you're gonna have the right to go pull their credit for something. I think that was left in for rentals. Because rental companies will want to pull it. However, it's somewhat been determined that these don't apply to commercial or rental properties. So we'll see how that all works out. Yeah. They're adding negotiating, so that your obligations, there you go. They deleted this because they're gonna relocate that paragraph somewhere else. Consumers' obligations, again, all they're doing basically is changing all the buyers to consumers. So it looks terrible, but it's not. Consumer understands that even if broker is compensated by owner or a real estate licensee who is working with the owner, such compensation does not compromise broker's duties to consumer. Still nothing going on. That just means you can work with other buyers. So let's say the buyer says, I'm looking at a specific house, and you have other buyers that are looking at a specific house. You're allowed to show the other buyers, work with other consumers, as long as you're basically not disclosing any information. Consumers' obligations. So here's where we're gonna talk about, let's see. Oh. So some of the notes I made back to here. So if you're a single agent to the buyer and you're a single agent to another buyer, and the first buyer offer gets accepted, they do an inspection, and now it comes back bad and says, I don't want to close. And then you have the other buyer that says, hey, good news, that just came available. What are you supposed to tell that buyer about the prior inspection that you're not supposed to talk about? Because, I mean.
You're supposed to,
Well,
we
yeah,
have to know about it,
Right.
that could materially affect their.
Right.
But
Which-
the seller should have to disclose it.
Cause they know about it.
No, but you know about it.
Yeah, but so.
Don't ask them.
Then don't tell them.
Yeah, that can cause the next sale, too.
Then buyer number one comes back and says, you know what, I changed my mind, I do want that property. Now you've already disclosed to buyer number two about the. I mean, some of the stuff, I don't know, I just wrote, what if broker has knowledge of bad stuff from prior inspection or report or,
You're required.
yeah.
That's the same if you got a seller.
But that's nothing new.
I think, like,
To,
it sounds simple what to disclose if you know, but I mean, inspection reports, what if the GFI is not working and you don't tell buyer number two is, I mean, there's gotta be case out there that
You're better. to
somewhere,
disclose.
yeah. Hand them the whole report. I mean, they didn't pay for that report.
Yeah.
Yeah.
I mean, if for me, I would go to that buyer that canceled and go, do you want to sell that inspection? I got another buyer. that wants
Yeah, I mean, when they say no, and you're like, well, it was 3 months ago when I read that report, I remember there's something wrong with it, but who knows? Anyways, that's a little off topic. So
Yeah, we
Paragraph-
come to buyers, the new buyer, they get their own inspection anyway, so.
They should, yeah.
they don't have
but
to
you have,
do that.
if you're single agent, you have a duty to tell them everything you know. Duty of loyalty, obedience, all the fun stuff that's.
And even if you're a transaction agent, you're required.
I think when they came up with the single agent, they looked at a dog and said, okay, what does a dog do to me? Those are all your responsibilities to act that way.
My dog.
So consumers' obligations, basically 5A, they just changed seller to owner and buyer to consumer and removed the financial, and everything else the same. G, you have to use diligent, good faith efforts to perform. That's the consumer's obligation. That's really, yay. The main stuff is gonna be down here. Now retainer. I gotta imagine some people that are part-time agents representing buyers may go into some sort of like a retainer thing saying, hey, for $500, I'll show you properties, but you're on your own for the rest or whatever. Notice how it's a non-refundable retainer. Non-refundable retainer. That means once they give you the money, it's yours. You can decide whether if the buyer actually closes on something, you get paid more money. So maybe you charge a retainer plus the compensation. And understand, if you charge a retainer, this is different. So even though they say you can't earn whatever in addition to what you've agreed to, you can charge $1,000 here and 3% down here, keep the $1,000 and get the 3% at closing. This is not included in this amount down here.
In addition.
It is an addition.
It is just like, it would.
It's right here. Retainer is in addition to any compensation earned by broker down here. Now,
Can you cross that off and put refunding?
well, what you can do is you can say, hey, if you close, I'll give you that credit at closing against whatever my commission is or something like that. But just know what this is for and that it exists. And really, this is on the buyer side. So if you're a listing agent, I mean, that doesn't necessarily matter too much to you. But here's where obviously all the changes come in on 7. Let me see if I have any other notes on these little. Oh, so on the retainer, let's say it's a FHA VA buyer. Everybody signs a settlement statement. Everybody signs a settlement statement saying settlement statement is a true and accurate depiction of the. Nobody has done anything outside closing. So now as a closing company, I may or may not even know that the buyer paid $1,000 to somebody, but per federal statute, it's supposed to show up somewhere in a settlement statement, like a POC to you or a lender's disclosure or something like that. So I don't know, one, how I'm supposed to know about it, but some of our federal closings, it's got to be on there somewhere, but
That retainer had to go to our broker first.
yeah, everything goes to your broker.
And is it held in escrow or is it just paid then directly back to you?
It's a-
I mean,
It's however they want to handle it, but it's, according to this, it's non-refundable. All right, compensation. I don't have any other notes on that one.
It's not around 1099.
Hold on.
It's returned, please.
Paragraph 14. Okay, so my note on the retainer again was, even though paragraph 14 is going to say that your commission can't exceed any compensation set forth, that it's got the language right here that this is an addition, so that overrides it. So, all right, so paragraph 7, if you're a buyer's agent, is really where your questions come from. The red line's hard to read, so let's see. Broker's compensation is earned when, during the term of the agreement or any renewal or extension, consumer or any person acting on behalf of consumer. So what that means is, do I have to worry about that John put under contract, but John's not gonna close, gonna move it into an LLC, or family member's gonna do it, or something like that? Supposedly, this is good enough to cover. I would say if you know that's the case, get an addendum or something. There's good, better, best. You're supposed to be covered, but be aware. The compensation is for broker services for consumer. Compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amounts owed by consumer. So the default is if you're a buyer's agent and the seller or the seller's broker is paying you, whatever numbers you have in here are automatically reduced. That make sense?
To what the seller,
They
to
need
what
to
the seller's
match what
getting.
the seller's
Right.
giving.
So this is an agreement between buyer, broker, and buyer. So I'm the buyer, John's my buyer broker. I sign this going, hey, if the seller's not paying, I'm agreeing to pay you 3%.
Okay.
However, if we go under contract and the seller's paying out 3%, this says I get credit. You can't go.
That's cool.
Yeah. I mean, that's what the intent was supposed to be, yeah. Now, unless you do leases or options, then you're only gonna be dealing with paragraph A. Which again, this is where in paragraph A, let's say you have a TC fee or you have a transaction cost, you're gonna put 3% plus your transaction cost. That make sense?
Yeah.
Okay. If you don't, if you forget, if whatever. So a lot of times, like when we're doing closings, we'll get a DA and then it'll say, oh, there's a transaction fee that was supposed to be collected on the settlement statement, but then I already sent out settlement statements, already whatever, and a lot of times we get DAs after closing.
So it has to be here where you put your fee.
Correct. Well, for the new law, it's gotta be there, otherwise you can't collect it. But don't forget, the closing company usually doesn't see this unless you present it to them, so I don't know
The
what it
union
says.
is how, yeah.
So who sees it? Just you and the buyer, right? And the broker.
Yep.
Well, yeah, and you're gonna have to, depending on which other document you're using, submit it with an offer if so.
Submit this with the
No,
offer?
this isn't for the
Not
offer.
this.
No, the other one.
The other one.
Yeah.
But once we go under contract, if the buyer's paying me directly, I should attach it to the contract when I send it to you or to any type.
Yeah, to-
Right? So that you guys know who's paying me, correct?
So I told my office today, at least when we hit August 12th, we're gonna have to ask listing agents and buyer's agents for the commission documents, just so we can see.
Right,
In the
but you
past-
guys need to know, right?
Correct. In the past, we've traditionally just called the listing agent, said, total commission, what's the split? Because I know even at the last minute, if it's wrong, we can just switch it on the settlement statement. Right, because it's a broker to broker issue. If there's a dispute, we're still closing. But now this brings in buyers and sellers money, so we may not be able to close if there's a dispute.
And there'll be some, I'm sure.
Oh, yeah. All right. And then, I mean, again, it looks terrible, but really all they're doing is changing out terms, consumers.
Mark, what if, the buyer doesn't sign it until after the contract?
It's easier to do.
Yeah.
At that point, it's easier to do.
So
Right.
then you would have to presume that they never saw the property, because they have to see the, before you can show them the property, they can see the property, or you
So the
can, at
buyer's agents really need to sign.
the beginning, upfront, yeah.
But we know they don't.
Well, then they're wasting their time.
Okay.
You're subject to wasting your time, right?
But, so what happens, like, you know, I'll have a client just call me and see something on the market.
Mhm.
Say, I'm not in town, go put an offer on it.
Then
Do
you're
I
gonna have to, you're gonna have to get them to sign an agreement first, otherwise you're wasting your time, and I don't know what Keller Williams is gonna say.
You're right, Bob. When they sign off.
Because you're now working on behalf of, so you're
Okay,
gonna have to have
but it's
listed.
just regarding that one property, in the very beginning of this, do I still put general Okaloosa County, or do I need to put that address?
They have different buyers agreements then, right? For one day, for.
Well, those are the showing,
It doesn't give you any.
But I didn't show it, so.
right. So they try to create 3 documents that if you're going to go around town showing, those are the minimum required per NAR settlement agreement. According to Andrew, even though NAR or ECAR requires one of those 3 as a minimum to show property, they're also requiring you guys to get the buyer to sign a single agency representation. So that's a minimum to show. If you're putting an offer, you're definitely working on behalf of the buyer, so you gotta get the buyer to sign something.
Right. But I'm asking you, how, if I build this out, how do I get the very first page of it
when it's saying, do I need, if I'm just doing it for this one property, or do I need to pretend
Well-
I'm showing it, and I just say ugly as the county? Do I need to put the address of the property, or just?
You don't have to with this agreement. Yeah, because what happens when they submit the offer, because they lowball.
They don't.
Right.
And then they go, okay, now let's do it on the unit right next door. If you put specific, now they gotta do another one to get them to sign it. So I would leave this as generic as possible.
Not too big.
Mark,
Yep,
can we talk about the questions a little bit more? Because a lot of what we do is, we get a phone call, they
Mhm.
want FaceTime showing.
virtual or in person, it's the same thing, doesn't matter.
So are we doing the broker, or are we doing the showing agreement? What are we doing?
So that's entirely up to you. Which we haven't got there yet, because we haven't done those 3 other things, but it's entirely up to you. But what Andrew is saying is, even if you do any one of those showing agreements, you still have to get them to do the single agency agreement. So my logic would be skip those and just go straight to this.
The buyer broker.
I told
There was a great video on that, it's like a single on those,
Great, right.
the date, like.
The dating, the
policies,
married,
dating
yeah.
and married. And that married one, I've already had that I've been working with.
Yep.
She's here, but she goes to me yesterday because I said something married.
Right. So what she's saying is, if you go to floridarealtors.org, Joanna did a video on those 3 agreements, and it kind of explained the difference between the 3 agreements. But even if she uses, the first agreement is just, hey, we're having coffee, we're not doing anything. The middle one's like, sort of, we're dating, and the final one is like, oh, we're married. But if you read it, no, you're not. I would just skip straight to this one.
This is the only one they get to marry.
And the TN.
And then.
Where did you say that Johanna video was at?
FloridaRealtors.org.
Okay, so it's uploaded on there. Okay, thank you.
So just the buyer to sign a buyer broker. Unless you click over A, B, or C.
Right. Pretty much it.
That's the major change. You just gotta.
Except for your dialogue with both the buyers who goes, I don't want to sign it saying I owe you permission. Why am I signing it saying you owe me permission? Well, NAR's on a lawsuit and now it's required if I'm gonna show you any property you're doing. It's not my fault, sorry, go ahead. Well, what does that mean? So you're gonna keep.
Oh, we're all in the same boat, right?
Yeah.
Around the year, we'll get separated, because I didn't do it before.
Everybody has to do it.
Okay.
Mark, can you repeat this question?
John, he's just reaffirming that listing agreement, the main thing is paragraph 8 and 10. That's kind of the same old, same old. And then on the buyer's one, you get them to sign it, and that's really the major changes. Yeah.
And all this red's gonna be based on the new ones.
It's all black.
Well, red just means they made a change, so red, underline, they add, red, strike through, that was, they crossed it out. So in this exclusive buyers, they've got the, let's do protection period. So you're gonna want a protection period, and I kind of recommend 90 days. Because what'll happen is, you're gonna get a buyer who's gonna call you and go, oh yeah, I'll sign this, I wanna see all these properties, so you do the work, you hand them all the MLS printouts or whatever it is, and then they're like, I don't want you anymore. So you're attempting to protect, and you're gonna, I don't, whether you wanna keep track of all the properties you hand to the buyer, it's entirely up to you, because it may close a month, 2 months, 6 months. So it's up to you on how much you want to track the properties and things like that. But I mean, the reality is, even if they close, you gotta go sue the buyer for commission. So imagine somebody that's VA or whatever, and they don't have any money anyways. It's in here for your protection, but I think in the real world just isn't gonna work. So basically what that means is, in order to show them property, you make them sign this, but, and under conditional
And then don't show
termination.
property if they don't, right?
Right, if they don't, I mean, that's the whole reason to get them to sign this. is because
Don't show property if they don't.
they're wasting your time, you're not gonna get paid for doing your job.
So you meet a buyer and you said, you work with anyone? No, I think they, or yes, have you signed anything with anyone? No, but they're lying, and then you're going out with them and they sign with you. So what happened with this buyer that signed with three of those?
So there's still, well, there's still procuring cause, and that would be an E-car dispute to determine who is the official procuring cause agent. That's how they're saying that's gonna be solved.
If they're lying,
If you didn't have a form signed, you're certainly not gonna get procuring costs. So
Correct. Yeah.
that should be their first interaction with anybody.
So if they do that, Mark, and they go and sign an agreement with John, and me, and so.
They're gonna owe 3 commissions.
3 commissions.
They could be sued by, they could be sued by 3 different people, but, I mean, there's language. Yeah, there's language in here though, so let's read this one.
Yeah, let's read this.
So broker may agree to conditionally terminate this agreement. If broker agrees to terminate this agreement, consumer must enter in a written agreement to this effect and pay a cancellation fee, of which I understand you guys don't really make anybody pay any fees if the buyer says, I don't want to deal with you. Broker may void the conditional termination, and consumer will pay the fee, stay the compensation paragraph, left the cancellation fee from the early termination date, blah, 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 goes on and on and on. Consumer contracts to acquire any property which prior to the early termination was found by the consumer. So that's again saying you're vested, but if, my understanding is your documents say if you agree to cancel and that buyer goes to another broker, basically you're out of it.
Right, if
If
you
you
can't,
terminates that, yeah.
but if you didn't.
Like a listing agreement, you
Right.
can cancel, they can cancel one.
If, so in that one, it's clear you've released them from you
Yeah.
if you agree to cancel. On the one where they sign
And here you
3,
got a date, it goes beyond the date.
And if it goes beyond
Protection.
the 90 days
that's
or whatever, yeah.
it should be.
I
yeah,
know because
different.
I have one lady, she wants to buy next year, so she just wants to get familiar with the area, so I would do a 2-year contract with her. Say, you're stuck with me.
Don't worry about it, I'll sign her up for 90 days.
Or you- Stand by.
Lucy, tell me I'm working on vacation, I said, I don't worry about it.
They did go out and sign it, John, me, and we go.
Right.
What happened?
Well, per the law, if they close and neither one of you get paid, the 3 of you go sue that buyer for your commission. They signed a contract that said, if you show them a piece of property and they close on it, under the term, you're entitled to whatever, 3%. You can sue them for 3% of the purchase price.
If they sign with me and then they sign with John, it doesn't terminate mine.
No, if they sign with you and you agree to terminate, then they sign with John to terminate yours.
How do you prove that you showed it to them before the other person they signed?
Well, you got,
That's what I
that's
mean,
where it
like,
goes, you know, cover your ass, cover your ass, cover your ass. If you show a house, make sure you have a follow-up email saying, hey, it was great seeing you today, I'm glad we showed you, and you list those.
You have to track every single property and keep notes. if
I
you
would
wanna
put
go
a
down that
link
road.
from the MLS because it disappears in 30 days, so you put the actual address in that email.
I wouldn't even bother, I wouldn't even bother, be like, whatever, but if
But yeah,
I just.
depends on the price point, I think.
Yes, yep, yep, yep.
That one?
So they're cutting and pasting dispute resolution. So again, do not initial here because that's no bueno. We already talked about that. And then down here, we've got electronic signatures are acceptable and binding. Brokers' commissions are not set by law. There's your disclosure. Brokers may receive, may not, so this is on the buyer side. Broker may not receive compensation from any source that exceeds the amount or rate agreed to with consumer. And again, this is where
That's 3%.
if they're offering, if the seller's offering more than what the buyer agreed, you have to get the buyer to sign a modification and make sure before settlement date that that's all signed. Otherwise, I guarantee you, there's gonna be agents that are not gonna tie this up, and eventually there'll be a pattern, and that's where you're making your broker responsible for not following the NAR settlement rules. So, but again, we go back to the retainer thing. I mean, if I'm not told in the settlement statement that a retainer was done, I never know that it's there, so my settlement statement's not gonna show it. Yeah.
So as a closing attorney or any title, company around here,
Mhm.
I've got a buyer broker agreement, let's say it says 3%. We go to look at John's house, his seller's gonna go offer 2%.
Mhm.
So we agree to do 2%. We get the, or seller's broker, buyer broker, everybody signs off on that, or I'm sorry, I take that back.
Yeah, right.
I'm backwards on that. So he's gonna offer 4%. We're gonna have fun here. So he's gonna offer me buyer's agent 4, and I've got one at 3, right? So I can only get 3.
Mhm.
That's what I've got. But how are, like, you gonna know that, because like you said, you don't get this, so you don't see that there's actually a spread between what was agreed to and what was the actual signed by the, on the EVBA.
Well, what does that have to do with closing side of the world?
Well, no, because there, we can't get more than what's on our
form.
Unless we do a modification.
So,
Here's a better question.
yeah, I'm gonna,
The buyer won't sign
hold
it.
on. I'm gonna pay out whatever you guys tell me to pay out, is, I'm not in violation of anything. It's your, when your signed document that you give to Doug says 3%, and the settlement statement said 4%, Doug's gonna go, I'm not giving you a check until you have a modification signed by the buyer saying 4%.
I know, so in the past, and this is a question, I don't know if it's changed or not, in the past, I know if you have a buyer exclusive agreement and they put it, and they say, I'm gonna pay you, 3%, the buyer signs to that. And then the seller only pays 2.5%. We have asked in the past for the buyer to pay that difference, that 0.5%.
Per contract, that's what it says, you pay. So when you're negotiating and you realize that John's a cheapo, not John, but his seller. And there's a 1 point spread that they're not willing to pay, then as the buyer's agent, you have two options.
I'm talking reverse.
Right, no. So you have two options under this scenario. You go to the buyer and go, I'm willing to waive 1%, or you do understand buyer, since they're only, the contract you sign says you're paying me, and then the buyer goes, oh my God, you know, that's what you're.
That's when you give up that 1%.
Correct.
And suck it up.
Cannot exceed.
No,
Cannot
I
exceed.
was talking about the reverse scenario of that.
The
Not
VA is
the
on
reverse.
board with all
You
this?
have to get the seller to agree to
No,
change.
you have to give a buyer.
VA and banks are on board with all this?
So,
Gotta agree to it.
so the VA wants it all to be called concessions. But you can't use the term commission in concessions.
Right. They don't.
They're concessions.
But you say that, wait until somebody actually is working with a buyer and the buyer's agent says seller's willing to pay 6% in concessions to the buyer. Guess what you just heard? Oh, cool. I get 6% of my closing costs paid for, and they're gonna pay your 3%. This is
Then it's
fantastic. I
going
love it.
back to this business, right? How much are we paying?
Correct. So you're gonna have to make sure when you're reading the agent remarks on sellers willing to pay concessions, as a buyer's agent, you're gonna have the script that says, since it's 6%, there's a presumption 3% is going to be, and you're gonna get the other 3%.
I thought we couldn't make any remarks about concession in.
Concessions are fine. Concessions are fine. Commissions or compensation is not.
So they said, like, if you wanted to say like closing costs, you could say seller will pay up to 5,000 concessions for closing costs. So
That's
that's
really
a pay the
important.
envelope.
But that's for the buyer, not for me.
That's right.
But the buyer can apply it,
Plus, you could put that if the seller wanted to do like maybe that, right?
but the buyer can apply their concessions however they want, including your commission.
Compensation.
Right.
And is that an
Your
addendum?
compensation, I gotta learn to speak right.
Why would that be an addendum?
She's right, sounds smart.
Like he's just asking, like, if let's say, like maybe per contract you get the concession or you write it, is it gonna be an addendum though, like they're gonna pay the buyer or whatever, agent or whatever? Or they're gonna get it at closing for their closing costs, is that what you're saying, Doug?
Going crazy.
The buyer's gonna look at the MLS and it says, seller's willing to pay 6% concessions to the buyer. Buyer's gonna submit an offer of which they're gonna include the either seller to broker or broker to broker of 3%.
Yeah.
And then the buyer just needs to understand they're getting the other 3%
Oh,
off of it or whatever.
Okay.
Does that make sense?
Once you can pass on smoke, it doesn't seem that hard. If I was just starting to be like, okay.
It's just a sudden change, I think, and people are just like trying to read too much into it.
Now, this little last sentence is for, however, consumer agrees that broker may receive separate compensation from owner, which is seller, of the property for services rendered to seller by broker for which consumer is not responsible. So that means if you're the listing agent and the buyer's agent, no, that means you can get your 3% from the seller, 3% from the buyer. Or if you're a buyer's agent and the seller says, come mow my lawn, I'll pay you $500 or whatever, you can work directly for the seller slash owner and get paid separately, as long as you're not breaching whatever your duties are, whatever contract you're using. So.
Just read them
Makes sense? Yeah.
So we're not working for.
So Mark, the seller pays.
And the only difference between all the other ones, just like the listing ones, they all say the same thing, it's Spotify.
Thank you, sir.
You sent us the one with all the red lines, right?
Well, they're all on realtors. Well, you know, they know. I didn't say
Thank you, Mark. Thank you, John.
This one came out August sixth. That's your compensation disclosure to the seller about basically just this language right here. So if you have a listing and it's not under contract, everyone's required to send it to the seller.
What's that called?
Disclosure. Compensation.
That's for growing.
Okay. You betcha.
It's your.